Hi, Stefano Molea here, San Diego criminal defense lawyer and partner at the law office of David P. Shapiro, where we help good people regain control of their future when charged with a crime. And in today's video, I want to talk about a specific situation, one in which there may be two people charged in the same exact case, commonly known as co-defendants, and the prosecution attempts to introduce the statements of one co-defendant against the other. So let's say that a co-defendant is interviewed, and during that interview, she makes statements essentially incriminating the other person that's charged. We'll just call that other person the defendant. Can that come in during a trial? The answer to that generally is no. And we call it the Aranda-Bruton rule, and that's based on a couple cases which held that because of a defendant's right to confront and cross-examine a witness that is making incriminating statements against them, it would be unfair to essentially be permitted to introduce statements of the co-defendant that puts the defendant in a bad light, right, that incriminates the defendant in some way, but then not allow that defendant to cross-examine the co-defendant about the circumstances or motivation or bias for making that statement in the first place. Obviously, cross-examination is the most critical part of a trial. It's where, it's the truth-seeking tool, as it's referred to in a lot of sort of settings. And so the general rule is the statements of one co-defendant cannot be used against a defendant in the same trial. Now, there's actually an interesting case before the Supreme Court that is going to address a situation in which the trial judge tries to sanitize the statement made by the co-defendant against the defendant. For instance, let's say that let's say that I'm charged with a crime and it's a homicide, and I'm charged along with the co-defendant. And the co-defendant says, yeah, we both went over, there was an argument, and we both decided that we were going to shoot this person. And Stefano was the trigger man. Let's say that I'm obviously charged. I never made any statements. I'm professing my innocence, and now I have my co-defendant saying that I'm the one who actually shot the person. Can the court sanitize that co-defendant's statement to essentially say something along the lines of, I was there, I didn't shoot the person, another person was the shooter, and not specifically name me, Stefano? There's sort of an issue with that, right? Most people would find that a little bit problematic in light of the confrontation clause and the right to confront and cross-examine a witness against you, because of the fact that even though I'm not personally named, if I'm charged as being involved in the killing of this person and there's this mystical other person, well, who else is the jury going to think did it, right? I'm not named, but it can be inferred that I'm the guy that's being referred to in the statement. So that case is actually before the Supreme Court right now. My hope is that the decision will be favorable to the defense, and at least in my opinion, consistent with the confrontation clause and the current state of the law, which is, no, that's not going to fly. It's obvious who the person is, and you can't just attempt to sanitize a statement. It can't come in, right? So that is a very broad overview, basic overview of that type of issue. So in particular in co-defendant cases, everybody needs to be very aware of that and, sort of listen for any attempt by the prosecution to introduce that type of statement. And frankly, the defense lawyer should be anticipating that issue and addressing it before the trial begins in limine motions. And we have a video on limine motions if you want to learn more about exactly how that works. So hopefully this this information was helpful. If you have any questions, feel free to leave them in the comments, or of course you can give us a call. Again, I'm Stefano Molea, partner here at the law office of David P. Shapiro. Our phone number is 619-295-3555.